So we have 30 questions right now, which is great. So we'll just start plugging right through those. The first question is, a homeowner put up an awning knowing it was against the rules without approval in an area that the association is responsible for. Does that mean they take on the responsibilities of the awning for any repairs and any liabilities if damage is done to the building, or if for some reason it gets blown off and a person or vehicle gets damaged? How do we handle this? Who is liable if the homeowner sells? Who takes on the future liability? Okay, I don't know how long ago this was, that this person put up the awning. If you're still within like 2 years or less, this person put up the awning, the board is still within their rights to enforce this as a violation. If the board wants to, they can also try to come to an arrangement with the owner. Just, it's an unfortunate situation when an owner puts up something that they didn't get architectural approval for and it's a violation of the documents, right? Either we have to spend money by going to, Superior Court and filing a lawsuit, or we go to the Arizona Department of Real Estate and ask for a ruling from an administrative law judge, or we, make an exception. Maybe it's been there longer than 2 years. And as part of the exception, maybe we have a written agreement that the owner will be liable and they'll be responsible for repairs, or that it needs to be taken down if it blows over or whatever. And then we record that so that any future buyer that buys in is aware of it. Or maybe part of the agreement is that once the owner moves, they have to take it down and fix anything that is the damage on it. So this would be one you probably want to reach out to your attorney on to discuss further in terms of what's the best way to handle it. Question number 2, we have an owner requesting our landscaping contract. Do we have to provide it to him? So short answer would be yes. Under the law, you are required to provide that. If you want to, you can redact, meaning blacken out how much you're paying the landscaper, although I don't think you should do that. You're entitled to do that under the law, but there's 5 different other places they can find that on your budget, your year-to-date budget, your check register. So I wouldn't play hide the ball on that. I just give it to them. Question number 3. What is the usual process for increasing the number of board positions? We have 3, but we feel it would be better if we had 5. The best way to do that would be to amend your documents. Whatever document, lists what your number of directors should be. Make sure you're checking the CC&Rs, the articles, and the bylaws, because if you have to amend the document that's higher in terms of priority. So if it's only in your bylaws, then you just amend your bylaws. But if it's in your CC&Rs, that's the higher priority document in terms of conflicts, you'd have to amend the CC&Rs to do that. Question number 4, our HOA is in the process of annual elections. A form was sent out to candidates for candidate bios, which stated no more than 150 words. However, some people went online and were allowed full-page resumes and a list of questions to answer, unbeknown to the remainder who sent the paper form in. Needless to say, those who followed the paper rules looked ridiculous compared to the full-page write-ups. Is this legal? I don't know exactly. The facts are I'm not quite sure on this. So if they went online, I don't know if the HOA was managing this whole resume statement process, but yes, it's unusual that this was handled this way, and it should not have been allowed by the association. Whatever the association, put out to the membership, everything should have been equal, right? You can't change it now. And I think it's going to be hard to prove that because they had, their resume there, they were elected, although I 100% believe you that probably was instrumental in them getting elected. I'm not sure a judge is going to undo the election. What I would do just saying going forward is HOA should have, make it uniform on how these biographies and candidate statements are handled in the future. If these candidates went off and did it on their own on a different website, they're entitled to do that. So I don't know if that's what happened here or not, but they would be entitled to campaign. And, there's nothing the association can do about that. Okay, question number 5. Is there a proposal dealing with the preservation fee that HOAs are charging to eliminate this fee? It seems to be getting high and are maybe affecting the sale of the home. I'm going to go back up to our proposed legislation, and you may want to take a peek on, let's see, there's a bill, House Bill 2119, that was signed by the governor on April 10th. You may want to take a look at that. Right now, the current law is that, if you're going to charge a capital contribution fee, I'm guessing that's what you mean by a preservation fee, that the procedure to do that needs to be in your CC&Rs. And we actually have a cheat sheet on this topic that would be really helpful to you. It's called transfer fees versus disclosure fees. So I would encourage you to take a look at that. And that will be helpful as you navigate this. Okay, next question, number 6. Our HOA bylaws require 2 signatures on all checks, but the management company only has 1 person signing the checks. Does the HOA rule pertain to the management company, or are they exempt? So great question. So you have to follow your bylaws. So the management company should know better, but they're probably just doing it because no one's questioning it. As a board, you need to tell the management company 2 signatures on every check. It's in our bylaws. It's non-negotiable. This is how it needs to be done going forward. Okay, question 7. If board members conceal or misrepresent material facts from the membership involving a vote, is this a fraud? It's hard for me to say. I mean, fraud is very difficult to prove, right? There are a number of elements to fraud, so it's really hard for me to answer. Is this considered fraud? I mean, I guess what I would say is if they're concealing or not giving material facts from the membership, it's more likely a breach of fiduciary duty, meaning that they're not acting in the best interest of the association. Now, I don't have all the facts here. It could be they have to keep something confidential pursuant to a confidentiality agreement that's part of a settlement. So, I don't want to just pass a bright line rule on this. I think I have to hear all sides before I could be able to weigh in on that. Okay, next question, number 8. What is Arizona law on year length of board members? I'm not sure I really understand that on year length. Maybe you're talking about the fiscal year. So most associations have a fiscal year of December 31st, unless your association's documents say it's a different time. Very, very few say June 30th would be their fiscal year. Maybe you're saying, what about term limits? Is there an Arizona law on terms of boards? There really isn't. You just need to look at your bylaws. Okay, question 9. Is there a way to find out the type of group home, residential care home, preferably through a governmental organization? So yes, if you have a group home in your community, I mean, there's a couple ways you can find out. You can ask the owner, can you provide more information regarding, the group home? And that you're entitled to do that under the Fair Housing Act. You can go to your city and do a records request for information pertaining to the group home, because they have to have a license and permitting. So you'll be able to find it that way as well. Okay, question number 10. Can the board share a vendor or contractor list provided by owners from their personal experience to share with other owners without any endorsement by the board? I do see this from time to time where associations will have here's house cleaners, and here is a good plumber, or here's an electrician. I think I do see that for boards doing that frequently. And so the most important thing is that the board should have a statement on there saying that we are not endorsing these people, use at your own risk, etc. Is it something that I encourage? Not necessarily. Okay, next question. Number 11. When a board member is absent from a meeting, whether open or executive meeting, can that board member assign his or her vote to another board member as a proxy? So answer on that is no. Question 12. Instead of installing security cameras, a member suggested putting signs up indicating that the premises are under surveillance by security cameras. Is this false advertising that could possibly cause our HOA to be liable? So short answer on that would be yes. I would be opposed to your association putting up signs saying that premises are monitored if they're not actually monitored. I think that is a misrepresentation, and that could come back to, be harmful to the association if something happens and something's detrimentally relying on that. Okay, question 13, the board HOA management. does not respond to questions submitted via the management company's site. What is the service level agreement response time? Oh, excuse me. So the service level response time apparently is 2 days, I think you're saying. We're not allowed to speak to board members directly, only via site. What can I do? Okay, what I would do is I would go to your next board meeting and honestly communicate with your board and give them examples of the different times that you have reached out to the management company regarding the site, whatever that, I'm guessing it's a website, and ask them to, enforce that, say that we need to have timely communication back from the management company. We're not receiving it. We're asking for your help. And then the board should listen and take action on it. Communicate with the manager and the management company. This is not acceptable. We need to see improvement on this. There should also be a homeowner log that the management company keeps showing the date that the person called in and the response date, and maybe start asking them to put that in the board packet. Okay, next question. If a homeowner had delivered an appeal that includes a request for 33-1803 D1 through 3 to the community manager's office, the community manager fails to respond within 10 days, is the violation and any associated fine still valid? Okay, so this is a question regarding the records request. Owners can make records requests to the association. The association has 10 business days. Okay, maybe I misread that. Okay, so actually this is one where there was a violation letter, it appears, that's sent to the owner, pardon me. And the owner responded, by certified mail, which is something that there's a law that says that if a violation letter is sent and the association receives a certified letter back from the violator owner, that we have 10 business days to respond to the owner. Now, I don't know all the facts on this. Typically, what I notice in our industry is that the initial violation letter already has all the information that we're required to provide to an owner. So even if you send a certified letter after the fact, it may have already been in the first letter. So that's one thing. And the information that we're supposed to provide, just, under the law is we send the violation letter. If the owner responds by sending a certified letter asking for more information on the violation, we are required to provide them with what section in the documents has been violated, the date the violation occurred or was observed, the first and last name of who observed the violation, and then the process the member must follow to contest the notice. If all that information was already in the first letter, there really is no violation if they don't respond to the second letter. If it's not all in the first letter, sometimes maybe who saw the violation might not be in the first letter, then yes, there are penalties under that law, and the association, they have violated that particular law by not responding within 10 business days. Okay, question number 15. Our board raised our annual assessment last year by 20%. They said they had the legal right to do it based on state law. I don't know what statute allows that, since our bylaws specifically spell out our max rate increase, and it does not get close to that 20%. Is this a one-time thing, or can they repeat it annually? So what I'd like you to do is take a look at ARS 33-1803A if you are a planned community. And basically it just says, unless limitations in the community documents would result in a lower limit for the assessment, the association shall not impose a regular assessment that is more than 20% greater than the immediately preceding fiscal year's assessment without approval of a majority of the members of the association. So here's the bottom line. If your documents state how the assessment can be raised, and it is less than 20%, your board should have followed your association's documents. This state law kicks in when there is no limitation on how much your board can raise the assessment. It puts a cap at 20%. Or let's say your documents state the board can raise them 30%. This cap kicks in and pushes that down to 20% under the law. Okay, question number 16. Sometimes other board members want to hold grudges against the gadflies. How do you help them? How do you help get them to come around? I mean, I think talk with them about it as, board members, and just say, hey, we're running a business here. I know that Johnny Appleseed has been a thorn in your side, but We have to be professional, and we need to treat everybody in a professional manner. We can't hold grudges. We just have to move forward because it's holding us back from getting things done. Maybe a good time to bring in our firm to do a boot camp to talk through the issue and move forward. Question 17, during COVID, our board meetings were moved to virtual. Many complained about not having in-person meetings. It seems going to in-person meetings has not made any difference. Zero attendance. How do you recommend attracting attendance? We have kept up communications and have had community get-togethers. Well, I think, first of all, if people aren't coming to your meetings, it probably means they're happy. So that's a good thing. I think the best way to handle it is just to communicate with owners. Hey, we're having a meeting, and if you're interested in coming, come. And figure out which platform is going to get the most people. In our experience right now, most boards are meeting virtually because they like it, and people can, be in Wisconsin or Michigan or Minnesota in the summertime, and they can still participate in board activities. And so just figure out what's the best way for your board to get the maximum attendance, and then make sure you're providing notice 48 hours in advance of the meeting so that people know how to attend the meeting. Okay, next question, number 18. Are architecture committees looking into board approval or no approval for installation on EV charging stations in ground 2 level garages in 2-story buildings? I'm not sure. So I think you're saying, are architecture committees looking into board approval for installing EV charging stations? Okay, so I think this question is for condos. And so this is kind of an emerging topic, right? So electric vehicles and owners wanting to put in a charging station. I'm not sure if you're asking from just the board looking into this, or do homeowners want their own? Either way, the board or the architectural committee, if you have one, you need to be working closely together with each other, the board and the architectural committee, to navigate this. Whether you're putting in an association EV charger or an owner is trying to put it in, there needs to be a whole approval process through the association to do that. And you may need to do a policy, frankly, to have a policy for your community if this is becoming something that's happening frequently. Okay, question number 19, do you have strategies for when your gadflies are online on Facebook or whatever social media platform, but don't show up to board meetings or engage in official ways? Ooh, that's a good one. So you've got like a poison pen type person, who's out there in the community, trashing the board on Facebook or whatever. Yes, I do actually have strategies. So I normally do not recommend that board members interact with other people on Facebook, but there is one thing I do say that you can say. So one thing that you could do is, if you're on this Facebook page of this person, you could have a board member say, we encourage you to come to a board meeting to discuss this, period. We welcome to receive your feedback. We hope you will come to a board meeting to discuss this with us. Also, if the person's out there spreading a bunch of misinformation on social media, the board doesn't have to directly address that person and their allegations, but they could be putting out a positive message, positive, informative message on their social media platforms and through communication channels of the association, like email, etc., that directly counter that without calling that person out, and saying, oh, this person's on Facebook saying this. I think there's a way that you can just do like a summary of what's been going on at the association and handle all of the misinformation correction. Okay, next question from a former board member of mine. How do you handle a board president that talks too much, thinks he knows everything, and doesn't know how to properly run the board meetings with motions, discussion, and voting? Additionally, this president expects the management company to handle everything without properly policing the management company. Okay, I think these are all difficult issues. I think one way is to run for the board, right? Another way is to provide information to this board about these classes, because we talk about these classes. These classes would be helpful for this particular board. Suggest a boot camp where I come in and talk to the board is another recommendation. But raise your concerns as a homeowner in the homeowner forum of your association, that you have concerns about how long the meetings are going, and, you're concerned that they're not reaching out to their trusted advisors to get advice, and that the meetings aren't being run properly, and voting isn't being done properly, and that you don't think there's proper oversight, I think as a homeowner, you definitely have the right to raise those issues. But ultimately, you have to be on the board, run for the board. Consider removing them from the board. We talked about that process today. There's lots of different options for you as a homeowner. Okay, next question, number 21. What if someone is wanting to join the board in their new session and the owner are not in good standing, but the documents don't have anything written to stop this owner from running? So you have a candidate that's running for the board, but they owe assessments or they have a violation, right? If there's nothing in the documents prohibiting them from being on the board or running for the board, there's nothing the board can do. That person can be elected to the board, and the way to fix that would be to do a bylaw amendment clarifying who can be on the board, and who can't be on the board if they're not in good standing, etc. Okay, question number 22. Our rules and guidelines to a 7-year community prohibit certain palm trees to front and backyard. It's come to the board's attention that a few lots have planted these prohibited trees in their backyards without architectural submittal, and these trees appear to be well grown at this point. How do you suggest this be handled? I don't know how long the trees have been planted, but if it's more than 3 years, you're probably not going to be able to enforce it. You may want to reach out to the owners and send them a violation letter, see how they respond. Maybe they'll gratuitously remove them. I doubt they will. Maybe you can get agreement from them, that they won't plant anymore, or that they'll remove them when they sell their house someday. I mean, it's a sticky situation if they've been around for 3 years, because we likely don't have any legal remedies to make them remove it, because we'll be waived from enforcing it because so much time has elapsed. Okay, next question, number 23. We have a president that we want to be removed. If we as a board vote to remove that person and have a quorum of the board there, would that board member then be removed? So yes, if you have a quorum of the board at a meeting, and this needs to be done in the open meeting, not executive session, and you want the president, removed, you just make a motion, and if a majority of you vote to remove the president's out as their officer position of president. Question number 24. How do we resolve issues with the management company that does not answer phones and does not provide information requested by board members in a timely manner? They act more like we work for them rather than them working for us. Okay, I have a couple suggestions on that. I taught a class recently, like how to effectively work with management companies. It's on our website under useful videos. Take a look at that. That's a great resource for you. I mean, the short answer on this is, how do we resolve issues? Ask to meet with them. The president of the company, I think, is probably where you need to go. Give them, the violations of the management contract and tell them they need to improve. If they don't improve, fire them. But check out our video that we have on that. It was a really good class, and it had a lot of great information on how to effectively work with management companies. Okay, question 25. We had a notoriously difficult owner that read a prepared statement filled with false statements and innuendos of mismanagement of HOA funds at our annual meeting with 20% of homeowners in attendance. We indicated that we would get back to him with a response. What is the most effective way to rebut his false, uninformed statements and innuendo to set the record straight with him and, most importantly, the other homeowners in attendance? I would recommend having our firm or your attorney for the association hit back hard with a very firm letter threatening, with defamation and stating for the record the true facts. And you can send that letter to the membership, as, how the board, responded to that owner. Question number 26. Our HOA has a Facebook page that we use to communicate information to members. A few members respond to the post saying they disagree, and in their posts they are criticizing, cursing, making inaccurate assumptions, and name calling. I mean, if that's happening, I think there's a way that you can remove those comments from the post, which I would encourage you to do. That's inappropriate. Of course, they can express their opinion, but if they are, using bad language or making incorrect information, it's my opinion, that either you correct it on the record by responding or ask them to come to a board meeting, or you can remove it, especially if it has, a lot of swear words or whatever in there. That's not appropriate. We don't want, this is a business. We're running it like a business. That's how most other businesses operate. What you could do is reach out to them in a private message and ask them to come to the meeting to discuss it further and let them know why their post was removed. Okay, board members respond by validating their concerns, but correcting inaccurate assumptions, giving accurate information, and inviting members to attend the meeting. You guys already are doing the right thing, so that's great. This is getting tiring. What do you recommend? If it continues, maybe have your attorney or my firm write a letter to them, just the owners that are making the inaccurate statements, telling them, that basically they're engaging in defamation and they need to cease and desist. Otherwise, what you could do is if they continue to fight on, the Facebook page, you could, disable any attempt to comment by everybody. I mean, I hate to do that, but that's something else I suppose you could do. Next question is, what suggestions do you have for effective board member communication outside of board meetings that would not violate the open meeting law? Okay, so a couple things. Less than a quorum can talk about association business. One-on-one, you can talk about association business. Both of those ways are ways to talk with your other board members without violating the open meeting law. Okay, question number 28. With regards to requesting the yearly HOA financial audit for review, what should we be looking for or asking for in addition to the audit? I think what I would do is I would read the comments that the auditor writes in the audit very carefully, because that's typically where all the problems are. Question 29. Must an original director removal petition containing wet signatures be submitted to the board in order to be valid, or is a paper copy or electronic version pass muster? The statute doesn't really give us direction on that. Most of the time we get copies and it's signatures. I have seen electronic ones though, and we have to verify the signatures, contact everybody right away to make sure that they in fact did sign the petition electronically. I would accept all of them as legal counsel for the association, but I would send that letter out if we don't have, signatures, on a copy. I regularly would get the copied petition that has, signatures that are made by hand. If it's electronic, what I would recommend to the association is that we send out a letter to everybody who signed it electronically saying, we received a petition with an electronic signature for you. If you did not sign this or didn't want to sign it or didn't understand what you were signing, please let us know right away so we can remove you and give them a very short leash to respond. Okay, question number 30. What would be recommended percentage of quorum of homeowners needed to vote to change CC&Rs? Our quorum requirement is 40 and then 51% of that to make a change, which means only 20 of our 124 homeowners can make a change to our documents, which is concerning. Curious what the norm or recommended quorum and percentage of that quorum would you recommend to avoid having a very small minority making changes to the documents? I think most associations are going by just 61 or 67% of the membership is kind of a typical thing. That's kind of the benchmark lowest. If you're a condominium, you can't go any lower than 67% of the entire membership. So we wouldn't even be, 67% of those voting at a meeting wouldn't even be like the threshold. It would be 67% of all votes. Maybe what you could just do is say 51% of all votes. If you're a planned community, you don't have that 67% minimum. What I would say is reach out to my firm, to me, to discuss this. We can help you with an amendment, or to your attorney for your association. That can be done, but I do think, I'm not sure you're reading it right. And if you are, you're right, that's really low. And I would be opposed to that low of an amendment provision. Okay, question 31. How can a board justify increasing assessment levels, the allowable 20% per year, when they have not increased annual spending? The association has never had a formal reserve study to justify funding growth. Okay, so your board apparently is increasing the assessment rate, up to 20% every year under the Planned Communities Act. But they allegedly haven't increased annual spending. I I'm sorry to question you on this, but I find that hard to believe because every association is dealing with inflation. So, our expenses are going up every year for every association for at least the past 3 or 4 years. You're saying that the association has never had a formal reserve study to justify funding the growth. I do encourage boards to get a formal reserve study using a qualified and, certified reserve company. Here's what I would do. I think you got to go to the budget meeting when they're talking about what the increase is going to be for the next year. And usually in the budget meeting, it's usually in July, August, September, October, maybe November. They're talking about, okay, this is how much revenue we have coming in, and this is what our projected expenses are. And that's how they set their 20% increase each year, or whatever their assessment rate's going to be. So I would encourage you to get more involved because if I had to guess, there probably is a justification for that. Okay, question 32. When adding new amenities to green space, the green space has an easement with SRP due to power lines. What type of control does SRP have over that space and the community? I'd have to read the easement agreement. Typically, that's going to be like in the, sometimes it'll be on the plat, sometimes it'll be a separate recorded document to know specifically, what, do we have to ask for permission, or I'd have to know what you're proposing to put up. So, what type of control, that's going to be listed in a separate agreement or in the plat. Typically not that much control though. Like, I don't think they could, it depends on what you're doing, but typically it's just easement for them to use the space, not to tell us how we use the space. Okay, question number 33. Looks like we're down to our last few questions. The board made an additional assessment and added monthly dues for 6 months. There is no record on board meeting minutes. The board had a motion and votes to approve. Is an additional assessment valid? It's hard for me to comment on this unless I, would have all the facts, but something like this would need to be in the minutes. So I don't know if it was or wasn't, but it's potentially something that could be challenged if the board didn't formally vote on this and it's not in the minutes. Okay, question number 34. My neighbor and I are both being fined. She is a lawyer and they finally reversed her fines, admitting they just don't have the money to fix everything. But for me, they are continuing the fines and denying they reversed hers, denying they own the pipe that they admitted to her they own. It's attached to association-owned property. This is going to cost me massive amounts of money to fix. Isn't this selective enforcement? Underground pipes are always very complicated situation. You really have to closely look at your documents to determine who owns what and who's responsible for what. I think if I were in your situation, I would reach out to an attorney that represents owners against associations. If you want to reach out to my firm, I can give you the names of several attorneys that do that, and they can maybe give you some advice on this. Based on the facts you're giving me, it does sound like there's selective enforcement, but like I said, I don't have all the facts, so it's hard for me to, give a definitive opinion on it. Okay, last question, number 35. My HOA is having issues with new parking restrictions imposed by the city. Residents are refusing to adhere to the new restrictions. We have posted the new parking requirements, but most residents are not complying. The city recommends enforcement to include tagging the vehicle, towing the vehicle if it continues non-compliance, and fining the unit where the vehicle is located. Who is responsible for enforcement of these restrictions? The management company? Okay, question. Well, first, a few things. So parking restrictions that are, set up by a city through like a city ordinance, the city enforces those, not the association. Okay, so that we need to make that clear from the beginning. So if there's a problem on parking, you reach out to the city, find out which part of the city is enforcing them, and make a complaint. If the city, I'm guessing that maybe the association has their own parking restrictions and maybe the association is enforcing those. Typically the board is in charge of enforcing those, but parking is always a nightmare to enforce. I'm not going to deny that. Typically associations bring in a separate company at night, like a parking patrol company, and they document the parking violations. And if tagging the vehicle is a suggestion. Sometimes they tow it. Sometimes associations will boot it. But both of those, towing and booting, you need to have the right to do that under your documents. Finding the owner. I mean, parking is it's kind of a nightmare. And so bottom line, your question was, who's responsible for enforcing it? The association's board. Don't forget that our firm's next virtual First Friday event is May 3rd, Friday, May 3rd at 9 a.m. Hope you will join us for that. And that procedure for that is you get to ask questions and I provide answers for free, 1 question per person. Finally, I hope you'll be back here next month. How is it already May? It's shocking to me that we're already in May. On Tuesday, May 21st for class number 5 of our 2024 virtual HOA condominium class, condominium academy class. And we're going to be talking about a comprehensive guide to board roles and responsibilities. So we're going to tell you the skinny on everything you need to know if you're serving on your board, keep you out of trouble, to help you be productive and to follow the law and your documents. So we hope that you will join us for that class on Tuesday, May 21st at 11 a.m. on Zoom. So thank you everybody for being here today. We appreciate you and hope you have a great rest of the month. Take care. Bye.